Hey everyone, and welcome to This Explainer. I am absolutely thrilled you're tuning in today. If you're the kind of person who loves to see how complex systems actually tick under the hood, you are in the exact right place. Today, we're building a dynamic visual mind map. The goal? To completely demystify 5 highly complex types of contracts. We're going to take all that abstract legal jargon from the Indian Contract Act and construct a crystal clear, structured legal blueprint.
So, here is our roadmap for the journey today. First, indemnity and guarantee. Second, the law of bailment. Third, sale of goods. Fourth, contract of agency. And finally, partnership essentials. To make sense of all this, we'll be breaking down each chapter into its core subtopics. We're talking definitions, the essential ingredients involved, rights and duties, any specific types, and of course, the pivotal case laws.
All right, let's dive right into Chapter 1, Indemnity and Guarantee.
Okay, so starting with protecting against loss, there's a fundamental difference between these two seemingly similar concepts. Think of indemnity under Section 124 as a two-player game. You've got the indemnifier promising to save the indemnified from a loss. Boom, direct safety net. But a guarantee, mapped out in Section 126, is a three-player game. You have a surety, a principal debtor, and a creditor. The surety isn't just tossing you cash for a loss. They actually step in to perform a promise if that principal debtor defaults.
And this brings us to a massively important rule, the concept of coextensive liability. As Section 128 dictates, the minute the principal debtor is liable, the surety is equally liable. You can't just tell the creditor, hey, go chase the debtor first. No way. The Supreme Court of India, specifically Justices B.S. Chauhan and Deepak Misra, enforces this heavily. They've ruled that financial institutions don't have to act like property dealers, trying to squeeze assets from a debtor before knocking on the guarantor's door. You sign the guarantee, well, you share the immediate legal burden.
So, what about the rights? There are some very clear financial safety nets built in here. The indemnity holder, under Section 125, can recover damages, legal costs, and compromise sums. Pretty straightforward. But for the surety, the second they pay off that debt, they are instantly invested with all the rights the creditor had. They even get the benefit of the creditor's securities. Plus, if there are multiple co-sureties, they are legally bound to contribute equally. The law is incredibly systematic about balancing the scales once money changes hands.
But the law isn't just rigid math. Equity plays a huge part. Take the famous case of Gajanan Moreshwar Perelkar versus Moreshwar Madan Mantri. Justice Chagla made a really fascinating observation here. He noted that the Indian Contract Act isn't completely exhaustive. Under principles of equity, if an indemnified person's liability becomes absolute, they don't actually have to wait until they are totally bankrupted by the loss to ask for help. They can force the indemnifier to step up and pay them off early. It is a wildly powerful protective measure.
Moving right along to Chapter 2, the law of bailment.
So we're shifting gears from guarantees of money to the physical transfer of goods. Under Section 148, bailment is defined as delivering goods for a specific purpose, with a strict agreement that they'll be returned or disposed of once that purpose is met. Now, the absolutely crucial word here is temporary. Bailment is never, ever a permanent transfer of ownership. You are simply handing over possession. Think of leaving your favorite watch at a repair shop or dropping off a suit at the tailor.
Let's break down the exact ingredients that make a bailment legally valid. First up, there has to be a delivery of possession. This can't be actual, like physically handing something over, or constructive, like handing someone the keys to a storage unit. Second, it has to be based on a contract. Third, it needs to be for a very specific task. And fourth, and honestly this is the big one, there is a mandatory return of the goods in specie. That basically means you get the exact same goods back. If you hand over a gold bar to a jeweler to melt into a necklace, it's still bailment. But if you hand over cash to a bank, they don't give you those exact same serial numbered bills back, so not a bailment. Take away any of these ingredients, and the whole legal structure of bailment just collapses.
It's really interesting to see how the law balances duties here. The bailer, that's the owner, has to disclose any known faults in the goods and foot the bill for extraordinary expenses. The bailee, the person temporarily holding the goods, must take care of them just like a person of ordinary prudence would care for their own stuff. And if the bailee makes any unauthorized use of those goods, they are instantly on the hook for compensation.
To really anchor this concept, we have to talk about Atul Marara versus Bank of Maharashtra. People assume renting a bank locker is a bailment, right? Well, the courts ruled that the mere hiring of a locker is absolutely not a bailment. Why? Because you aren't actually delivering possession of your specific jewelry to the bank manager. You hold the key.
Unless you physically surrender exclusive control to the bank, that critical ingredient of delivery of possession is totally missing.
All right, let's jump to Chapter 3, Sale of Goods. We are now pivoting from the temporary possession of bailment to the permanent transfer of ownership. A contract of sale, under Section 5, is literally the backbone of all commerce. It's an offer to buy or sell goods for a price, followed by an acceptance. Sounds super simple, but the real magic is that delivery and payment can be immediate or they can be postponed. The core requirement here is the mutual agreement on goods being exchanged for a specific monetary price. If there's no money involved, it's just an exchange or a gift, not a sale.
What I absolutely love about this area of law is how perfectly it anticipates chaos. Like, what happens if the goods you just agreed to buy actually burned down in a warehouse yesterday, and neither of you knew? Well, Sections 7 and 8 mathematically map this out. The contract is just void if specific goods perished before the contract is made, or even after the agreement but before the risk officially passes to the buyer. The law steps in to dictate exactly who is left holding the bag when a transaction completely goes sideways.
And when a contract does break down, the opposing rights of the parties mirror each other perfectly. If you're a frustrated buyer who didn't get your stuff, you can sue for damages, or sometimes demand a specific performance decree to literally force the delivery. On the flip side, what about the unpaid vendor? If you haven't been paid, you've got incredibly strong remedies. A right of lien to simply hold on to the goods, the right to literally stop the goods while they are in transit to the buyer, and the right to just resell them.
Time for Chapter 4, Contract of Agency.
This branch is all about what happens when you empower someone else to act as your legal shadow in the world. Section 182 defines an agent as someone employed to do an act for a principal, or represent them to third parties. The crucial takeaway here is that the agent literally becomes the legal extension of the principal. When that agent signs a contract, they are creating binding, concrete ties between the principal and the outside world. It is a massive delegation of trust and power.
And there's a fascinating evolution of the different types of agents out there. You've got your standard auctioneers and brokers, sure, but look at the del credere agent. This one is really unique. A del credere agent earns an extra commission, and in return, they guarantee that the third party they find will actually pay up. If the buyer defaults, the del credere agent pays the principal out of their own pocket. They're essentially wearing two hats at once, acting as both an agent and a surety guarantor.
So what are the rules governing this dynamic? Well, the agent is strictly bound to follow the principal's directions and render proper accounts. But in return, the agent has some absolute rights. They have a right to their remuneration, obviously, but they also have a powerful right of lien. If the principal refuses to pay their commission, the agent can legally retain the principal's money, paperwork, or property until that debt is settled. It's a very practical balance of power.
And finally, Chapter 5, Partnership Essentials.
Moving from a single principal-agent dynamic to a collective legal entity, created when people combine forces for profit, the absolute defining hallmark of a partnership is mutual agency. Every single partner is simultaneously a principal and an agent to all their co-partners. If one partner signs a deal, everyone is bound. Another essential detail to note is the unique protected status of a minor. A minor can never be a full partner with liability, but they can be admitted to the profits of a partnership. When they turn 18, they face what's called a doctrine of election. They have to legally choose, become a full partner and take on the liabilities, or walk away entirely.
Because of this mutual agency we just talked about, the liabilities are intense. Partners face joint and several liability. The consequences of one partner's wrongful actions instantly ripple out to bind everyone else financially. And if things go completely south, the law dictates a very strict order of operations for the firm's dissolution and settlement. Accounts are carefully settled, the firm's goodwill is valued, and whatever assets remain are distributed mathematically.
Let's connect these final systemic risks together. In business, keeping secrets creates massive legal vulnerabilities. If a partnership doesn't actually register itself, the partners face severe limitations if they ever need to sue the firm or each other. It's a huge, huge risk. Similarly, an agency. If an agent makes a contract without disclosing that they are working for a principal, Section 233 kicks in. The third party, once they find out, can choose to hold either the agent or the hidden principal liable. The law always finds a way to pull the mask off and enforce liability.
And just like that, we've reached the end of our mind map. We've mapped out exactly how these legal structures work. So I want to leave you with the provocative thought to chew on. From merely handing over the keys to a locker, to a business partner signing a secret contract, when does a simple, everyday agreement in your life suddenly cross the line into absolute legal liability?
Hopefully, with this explainer as your guide, you now have the blueprint to know exactly where that line is drawn. Thanks so much for exploring with me, and keep learning.